Houston Maritime Attorney, who is an injured maritime worker, nationwide office in Texas, Louisiana. Just like any other industry, seamen are at risk of suffering work-related injury anytime they are not around the clock. The courts recognize this and are continually working to protect injured seamen throughout general maritime laws. Maritime laws gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation of any suffering medical complication. The following act are foundation to maritime law. Point 1. Jones Act. Point 2. Death on the High Seas Act. Point 3. Limitation of Liability Act. Point 4. Longshoremen's and Harbour Works Compensation Act. General maritime law is the basis for all injured sustained by seamen. It is important to have a comprehensive understanding of the general law before delving into the subsequent acts. How to use the how to use the right maritime injury attorney. Maritime law can be complex, although these law are designed to protect the right of maritime work who become injured or ill. They can be difficult to navigate. This is why it is crucial to seek legal representation from the attorney who has a deep background in this area of the law. It is essential to select an experienced maritime lawyer when choosing an attorney. You should inquire about the number of maritime cases they have tried. Don't allow an attorney to dance around you. Caution: you need to select someone who is prepared to give honest, direct answer to all of your inquiries. Avogadro's D lesson for accidents maritime Marimos by an Altamaran Houstons. The basics of maritime law. Maritime law is derived from many sources, including federal, states, and general maritime. These sources provide some of the maritime doctrines that are commonly used in the cases involving vessels and their passengers and crew. Maritime law sets forth many of the basics legal tenets associated with the sea and seamen's, including seamen's. Point 1. Seamen right to maintenance and cure. Maintenance and cure refer to the benefit seamen is entitled to until he/she recovers and fit for duty. However, there is maximum medical improvement limit that can control the amount of compensation received. Maintain include such expensive as the cement, rent of motors, utilities, property tax, house owner insurance, and food cure is similar to works compensation benefit for employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is captain or crew member aboard as well in navigation, also similar to works compensation. Compensation maintains and cure does not require that the seamen prove any fault for their injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen an statutory right to sue their employer for personal injury damage. However, a seaman must spend at least 30% of their time working on as vessel qualify for the Jones Act. Not only does the Jones Act provide the seamen a statutory right to sue their employers, it also issues the burden of proof needed to prove causation between the employers negligence and seaman's injury. Under the Jones Act, the employer's negligence only needs to play a part in the seaman's injury rather than being proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act, in particular claims filed in state or court under the Jones Act are not removable to federal court. The Death on the High Seas Act. When the death of individual are caused by a wrongful act or neglect occurring on the high seas, the DOHSA guarantees that a personal representative of the discipline can bring the saving to situation clause. Federal law establishes exclusive jurisdiction for admiralty and maritime case in the federal district court absent any language indicating the contrary within a statutorily created right, such as the Jones Act. However, the saving to successor cause reserve and non-admittedly remedies that may be available to an individual. An example of admittedly remedy is a suit in which the claims is brought against the ship, the Longshore and Harbor Workers Compensation Act. Federal law created certain statutory right of employees, not necessarily seamen, but who nonetheless work on harbors vessels that are under repair to being built. This law covers longshore work, ship repairing, shipbuilders or shipbreaker, and harbor construction workers. Injury must occur on navigable water on an adjoining area, such as a dock. This law provides of compensation and medical care for an individual injured while on the job, or survivor benefit. The outer continental continental shelf land and extended the LHWCA employs against of offshore drilling on the outer continental shelf. History of Admiralty Admiralty of Maritime Law. History of Admiralty of Maritime Law. Maritime law, also referred to and as Admiralty law, is nearly as old as the shipping industry itself. Govern most accident that occur on navigable water. The law's roots can be tracked back to the unwritten customer of nautical behavior of the Equipmentans. The Greeks, however, the earliest formal codes were established around 900 BC on the Greek island of Arhos. The original maritime law and codes stemmed from the ancient consumer and rules of shipping. For example, the doctrine of the general average, the concept that all sea cargo stakeholder ownership or etc. evenly share any damage or losses that may occur as a result of voluntary sacrifice of part of the vessel of cargo to save the whole, can be tracked back to the early shipping consumer of the Arhodians. The concept of separate legal authority regulating maritime issues was brought to the West by Eleanor Y. of Aquitaine, who learned of the concept when she accompanied, accompanied her first husband, King Loswell of France, to the Madrians on the second crusade. The terms admiralty law came from the British Admiralty courts, who preside over maritime matters respectively from the England Common Law Court as the U.S. Judicial system is based on the British system. Amendment Admiralty law were graduate, gradually incorporated tended into our legal system soon after the Constitution was retired. When does maritime law apply? The outskill industries and customer perhaps most obviously maritime law apply to events that occur on the high seas, accidents that happen beyond the territorial water of any country. Furthermore, maritime law apply to the territorial sea which has water when 12 miles off the shore. However, the law's applicability become less clear for the inland early in US history. Maritime law did not apply to incidents that occurred with the body of the country, and therefore excluded incidents involving the Great Lakes and nautical inland waterways. However, throughout the 19th century, this exclusion eroded